Johnson, and this is Focus on Liberia. Hit it! From Cape Mount to Cape Palmer, Mount Nimba to Atlantic Ocean, Obomi Hills to Pokonjre, to educate, elevate, and promote. Talk about home affairs, hey, in diaspora, current affairs, hey, reliable information, history, ooh, talking about culture, yeah, politics, education, entertainment, business, sports, advertisement, articulation. Focus on Liberia. Focus on Liberia. Focus on Liberia.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Dennis Jar.
And I am Anthony Sier, the person. Welcome to Focus on Liberia. This is our program, Focus on Liberia, just a forum dedicated to discussing legal issues. This time, a big one. The Supreme Court of Liberia has given an opinion in a matter that was brought to its attention by the embattled speaker, J. Funanti Kofa, some now referring to him as the removed speaker. To discuss all this, we have two outstanding legal minds who are always here helping us to unpack legal issues and provide the understanding needed for our people. Seated and ready to go is Focus on Liberia legal analyst, Councillor Frederick A.B. Jewell. Councillor Jewell, good evening. How you doing? Welcome.
I'm doing fine. Thank you, Tony.
All right. Also with us is an attorney at law, my good friend, Wanyane Konyenem Freeman. Wanda Konyenem Freeman, to put it right. He's an attorney at law. He's an economist and also a financial crime specialist, always here at Focus on Liberia to participate in the debate. He has been writing about how to move our country forward, especially on the issue of accountability and rule of law. He's with me here in the great state of Minnesota. How you doing?
Yeah, I'm great. Yeah, that's nice introduction. Thank you.
All right. And so, folks, in cyberspace, we want to say welcome to the discussion. The debate is on concerning the Supreme Court opinion or ruling, others would say. So we are here to do an analysis, and the legal minds here will do it. And I will ask all the necessary questions, and we will solicit your questions too. So put your questions in the comment. I will look through and ask those ones. I will inform the discussion. Let's get started. Councillor Jewell, let me start with you. And my first question is, did the Supreme Court give a definitive ruling in this case involving Funanti Kofa and what is now referred to as the majority bloc? Councillor Joel?
Yeah, I'm here.
Yeah, I asked a question. Yeah, go ahead.
Yes, from what the Supreme Court, what they handed down the 6th of December is a judgment
Okay.
on the complaint that Councillor Fonati Kofa and his minority group took to the court, to the full bench. I guess what is really debatable or being debated currently is who won and who lost, just to put it in the simplest way. Did the court rule and consider the action, the sitting, the decisions of the majority Black as unconstitutional, and therefore they are to desist and return to the House under the speakership of Councillor Fonati Kofa? Or did the court state that this matter is beyond our jurisdiction? There is something called the political doctrine question and separation of power. What the court did was to say, look, I'm sending back this matter, or we are sending back this matter to the House to discuss and resolve themselves. So there are people who are saying that Councillor Fonati Kofa, that was a judgment in his favor. And there is another group of Liberians who are saying that Councillor Fonati Kofa lost because all of the counts in his prayer, I think 5 counts prayer, were not granted. And so there where we are, based upon that, the majority and the executive have taken several actions, including the Minister of Justice writing an opinion. I hope I'm not going too far.
We will get to the details. What I want to get clear from you to start the conversation, you said the Supreme Court gave a ruling. I want to know, in your evaluation or reading of their opinion or judgment, was it definitive? Were there a directive in their judgment as to what should be done specifically to erase all ambiguity or confusion?
No, what the court did was to say, look, we are washing our hands from this matter. Let the House decide what they will do. In other words, the court did not decide in favor of any party.
So there was not a judgment, there was not a ruling. Is that what I'm hearing from you?
No, so there was a judgment. The judgment the court entered was just, the court said constitutionally, these are 2 equal branches of government, the judiciary and the House. The court cannot decide the issue or the conflict that have politically, come up in the House. So we will return it to the House and let the House resolve it itself. In other words, the court did not really instruct the majority to remove themselves back to the speakership of Councillor Kofa. Neither did the court instruct Councillor Kofa to go to the majority and preside.
Thank you. Before I get to Koyene, let me ask my final question. So all the prayers of Fonati, in other words, what he petitioned for, what he went to the court to seek, the court did not grant any?
No.
In its judgment?
No, the court did not address any at all. The court, one of the
You use the word addressed.
Using
the word grant.
Grant, the court did not grant it at all.
Okay.
So the court said there is a question of political doctrine where the court believes that a matter before the court can be much more politically addressed or determined, the court will not interfere.
All right.
That's what the court said.
All right. Thank you. Anthony Freeman, I was start the same question. Did the court give a ruling or a judgment? Others are calling it an opinion. Was their opinion definite as to what specifically should be done?
Yes, the problem is people have the opinion of what the court should do. They form a fixed opinion. Since the country is split into 2, one group is supporting majority Black, and another group is supporting minority Black, Fonati Kofa. They assume that the court ruling must be majority black won or Funati Kofa won. And since because the decision of the court was to say you didn't win and you didn't win, so people say the court didn't rule. The court ruled. And mind you, that is a standing rule in the court that they don't need to address your issues that you raise. They don't have to address it. They will address the one that they consider an issue for them. Okay. And that will be final. And there's nothing you can do about it. So you can put like 10 questions to the court. The court can answer one and decide the case. They can answer two, or they can answer none of your questions and still decide the case. In that case, it appears to me that the court answered none of Funati Kofa's question and decided the case. But people say it was not decided because they want for the court to say Funati Kofa won or Rachel Kun won. And the court said, no, they're not doing that. In fact, if you go to the crux of the ruling on page 34, the court is saying, the court, and let me just read it word for word.
Please.
Wherefore, and in view of the foregoing, blah, 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 members of the House are to conduct themselves accordingly. The court cannot do for the legislature what is in the purview to do. You got that? The last two paragraphs on page 34. So, then the court is saying, don't come to us. You own your own. You know, don't come to us. You own your own.
So, Anthony Freeman, that begs the question. I know you said legally the court can decide not to rule.
No, don't get it. The court will rule. But the court, you can put a question to the court, what we call issues. The court can decide.
In other words, the court ruling does not favor anyone. Instead, the court puts the matter back to the House.
Yes, that's what it did. That's what it did.
Okay, so my question now is, was that of any help? Did the court help at all in any shape or form?
Oh, yeah, it's consistent with precedent. It's consistent with precedent. If you go back, the court said that the only no precedent of this case is the Edwin Snow case. The political question doctrine. So, it is a long-standing principle which Funati Kofa knows that when a matter is what we call non-justiciable, that means it's really not a legal thing for the court to go split hair over. It's a political question.
Okay.
The court will throw it back outrightly. The court can avoid the question. The court can go and decide and discuss something else. Because the problem with the problem with Supreme Court is that whatever they do is final. So if they don't address your question, that's it. That's their ruling. You know, so people should not, the question say yes, no, or I'm not saying anything. So in this case, people want a yes, they want a no. The court said, no, I'm not saying anything. And you know, they cannot do for the legislator what the legislator is under obligation to do for themselves. Now, let me just add one more point.
Okay.
They made a lot of emphasis on Article 33, that when the minority members do not get a quorum, they can compel the majority to attend. And the court say yes. But what is the mechanism in your rules to compel? So what happened in Liberia, when the Constitution gave you a right, like your right to due process, some of it is under the criminal procedure law, some of it is under the penal law. When the court gave you your right to work, the statute, the labor statute, what we call Decent Work Act, that is the mechanism through which you can achieve your right to work. In this case, the court is saying to the legislature, why didn't you detail the procedure that you need to follow with a statute so that when the majority refuse to join the minority, detail it in a statute or in your rules so that we know what to say. But since you didn't do it, go back and do it.
So in essence, in their rule,
Funati wouldn't benefit from it because that would be expo facto.
Thank you. And so here's my next question, right? So do you actually agree or disagree with the Supreme Court? I know you explained that they don't have to, do any of the things Funati pray for. They could go to something else. And you also said that, look, Supreme Court is basically saying here, look, what you are asking for is something you can do that we cannot do. So go back and do that. My question to you specifically for the listening audience is, do you agree with the Supreme Court's opinion that is of any help in this way, the way they came down with this ruling?
But if you follow my commentary on this show, I have repeatedly said, and I disappointed a lot of my fans out there because they said I was supporting illegality. Because I said Funati is not going to survive, and there is nothing necessarily illegal about it because it's a political question. People were disappointed. I'm not disappointed in the court because I knew that's what they were going to do. Look, let me tell you something. There are two ways to legality. There is the de jure and there is a de facto. When something is written down on paper, that's the de jure, right? So we know that to move the speaker, you need 49 members, right? So that's the de jure process. It's written down on paper. We can all read it and understand it. But there's a de facto, and it's not necessarily illegal. The de facto is that when you lose the majority in parliament, you are kaput. You finish. That's the de facto rule. So Funati knows that there is a de jure rule and there's a de facto rule, and both are legal. So even though they may not have acquired the 49, which is the de jure rule, but the de facto is that once he cannot maintain a quorum, there is no way he can be speaker. It's not written, but the senior counsel will say more about that, but that's the de facto rule. So Funati is now learning that the de jure rule may say, yes, we need 49, but de facto, you need to constitute a quorum. If you can't, you're out.
All right. Thank you. And Councillor Joe, I'm enjoying the discussion already. So I know you said, I read your writing, you said Funati is done. It's obvious that you agree with what Konyonen just said. So my question to that is the whole issue about due process, which Funati is crying for. Do you think that his removal was not given this principle of due process, and so it cannot hold?
So, interestingly, the court did not even speak a lot about due process. The court, in its judgment or in its opinion, it first established, because that was one of the questions, established whether as a court, as the Supreme Court of Liberia, whether it has the jurisdiction or the authority to entertain the complaint that Councillor Funati Kofa and his group took to the court. The court answered yes, said being the court entrusted with matters that are constitutional to decide, the court has authority, has the jurisdiction to go ahead and discuss this case and make a judgment or write an opinion indicating what the court thinks. Now, the issue of due process clearly raised by Councillor Funati Kofa. Again, as Attorney Freeman said, the court decided to go on and decide this case mostly basing its judgment on Article 66 of the Constitution and 33. But then, in order to get out of, in order to not even answer Councillor Funati Kofa's question, the court went ahead and said, look, even though the Constitution, Article 33, said that the minority may continue to summon the majority to appear and come be present for the hearing or for the conduction of business of the House, you, members of the legislature, should have prescribed in your rule or by statute how would that have been done? Whether due process or no due process, or the court is saying, look, since you did not state in your rule or by statute regulatorily how this matter could be handled. The court will send the matter back to you guys to go ahead and decide it by yourself. In fact, this is a question that deal with the political aspect of how the House is to be run. We are not going to be a part of that. So the court left the due process issue completely, because had the court decided that due process of law was not accorded to Councillor Fonante Kufa, the court would have been under a clear obligation to say that the majority must return to the speakership of Councillor Kufa and continue to conduct business in a manner that they consider normal. The court didn't want to address that. The court did not address that at all. The court hung its hat on, you all go back, draw up a regulation or a statute in your rule to state how a minority may continue to summon the majority. Look, if you look at the opinion by the Justice Minister, the court. Let me go back to the court. The court did not even say sitting in the joint chamber was illegal. It didn't say that. The court said, y'all go back politically and decide this. In other words, whether due process of law, no due process of law, the manner and form to settle this matter is political. So if you ask me practically, who is the loser, I would tell you Councillor Fonante Kufa is a loser, because he was specifically looking for a means to compel the majority to return to his authority so that he could function as the speaker, because mind you, he was adjourned from day to day because he could not obtain a quorum.
Correct. So then my next question, if you read the opinion of the Supreme Court, it says here in the Honorable House of Supreme Court of the Republic of Liberia, sitting in 8 October term AD 2024, and then before her honor, and listed all of them, and then it says somewhere in the unconstitutionality of several actions taken by certain members of the House of Representatives. Yes, my question. Why are they using those words? The unconstitutionality of the actions of certain members in the unconstitutionality of the action of certain members of the House of Representatives. It said that they are saying, look, some members of the House of Representatives have behaved unconstitutionality, and we are giving an opinion in this. Tell me, Councillor Jewel, why they use those words? For a layman, I'm saying that, okay, these members behave unconstitutional. So that is why this opinion is being titled in this way. What is the meaning of that? What is your reading?
So that this is not what the court said. This is the caption of the case.
And who put that caption there? Because
this Councillor Fonante. Okay. So the court is just citing what they lay out. They lay out in blah 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 blah. The unconstitutionality. The court is not the one who captioned that case like that. It is how. Now let me go back maybe to provide some clarity. So this is not a case where it is.
Sorry, I need to stop you here. So it is Fonante who is trying to ask the court that, look, certain members of the House of Representatives have behaved unconstitutional.
Correct.
And now the court is replying to that request or petition from him. That's why they're quoting that. Is that correct?
No, the court is not replying. The court is citing it just how the complaint.
Okay, let's use the legal word citing.
The court is just citing how the petition is in blah blah blah. The court is just saying in the same way they got it. The court is not making a decision on that. It's not agreeing with that caption. It's just basically stating the caption as cited by Councillor Fonante Kufa and his team. If you, there are two ways to either for a matter to be taken before the Supreme Court. The key ways, two key ways. One is a matter could go before the Supreme Court by way of an appeal. John Brown versus or Lamco versus Firestone. Firestone could be the appellee, meaning Firestone won the case in the lower court. And Lamco could be the appellant, meaning Lamco lost the case in the lower court and is now appealing to the Supreme Court to hear the errors that Lango contain or says that the judge in the civil law code or in the code below made. This is not how this case went before. And the second way is that a matter can go before the Supreme Court by way of in re. What they're asking the court to do when the case is in re, the court is asked to look at certain constitutional provisions and either declare the action and the facts that were complained of to be consistent with those articles of the Constitution, or the Supreme Court will interpret the Constitution and say that, look, this is what the Constitution says, this is what the parties are to do. But in this case, the matter came from the House, which is a political, I call it political movie hall of one of the houses in the Republic of Liberia, meaning that political matters go on in there. It's not decided by a judgment what they're doing in there. What they are doing there is political. So they rely more clearly on the number of people they got on their side. So if you got, as I think Freeman said, if you have the lower number of people on your side, like in the case of Councilor Funati Kofa, all he could do basically was to, from day to day, adjoin. The executive is interested in ensuring that the 2025 budget is passed. The justice is interested, the executive rather is interested in making sure that ministers that, for example, the internal affairs minister who was supposed to appear before the Senate will appear, or before the House will appear. The scene with Water and Sewer, the director Mo Ali to appear. Those things, the things that run the government on a day-to-day basis, the executive have much interest in it. And so once the court ruled and said this matter must be decided politically, this is a political doctrine question, we will send the matter back to you all because there is no regulation and there are no rules that allow us to state what you are asking for in essence. It is about your function, go back and fix it. That level of decision is being debated. That the court should have said, oh, the majority, you are wrong. You should not be sitting in the joint hall. You should return to where Councilor Fonati Kofa and the, I think, 28 or 33 members are sitting to be part of that group. The court did not want to do that. The court went ahead and said, you're going to solve your matter. Right after that judgment, the Minister of Justice went ahead and issued an opinion. Right after that judgment, the executive started to inform Councilor Fonati Kofa, we come to take away your security people. If you are coming to do all of that to you.
And Councilor Jewett, this question is from somebody following here. That is Ambassador J. Hezekiah Siako Jr. He said, so what about the last paragraph on page 3? Are you familiar with what he's asking for? Or else
that paragraph is Fonati Kofa proposal.
Can you read it? Can you read it? So that
the Fonati Kofa proposal is not a code. People are misleading the ruling. The code ruling is to page 38.
Yeah, so
what is on page 3 is Fonati Kofa proposal to the court.
So let him read it. So that
let me read it.
Yeah.
So last paragraph on page 3 says, the member seizure and taking possession of 2024 draft national budget, although it was directed to Speaker Kofa in his capacity as a presiding officer of the House of Representatives and unlawfully acting on same in violation of Article 49 of the Constitution and Rule 1 of the House sitting. So
what's the title there? What the title say? That low in the middle, you see something there. What the title on top of it? Right in the middle.
The title say petitioner's petition.
Okay, so petitioner is Fonati Kofa.
Yeah.
So they're not a court ruling there.
So let me just, when a complaint is before the court, the court will cite the arguments from the petitioner in this case, and also cite the argument in, the returns what the majority black are saying the code will make.
Councilor, can you use the word code so that non-legal mind people will understand? Because if you say side, we will understand it differently. But when you say code, we'll know that they are repeating.
Okay. So the code will just basically repeat maybe. Not maybe. The code will repeat what the argument is from the petitioner. This in this case would be Councilor Kofa.
Right.
And also repeat the saying or the argument of the majority black.
Mm-hmm.
That is not a rule, it's not part of the judgment. All the court is doing in order to analyze the arguments from both sides, it will say this is what Councilor Fonante Kofa and his team said. That's all the court is saying in its judgment. It is going step by step to make sure this is what the other party said, this is what the majority said, this is what Councilor Fonante Kofa said. But you need to go to the wherefore. Once you get to that part of the decision that say wherefore, the court will have to definitively say what is it that is saying that what is it is saying in its judgment that is binding on the parties. This is not just the party, but this is a law binding on the whole entire Republic of Liberia. In other words, no other in the absence of a rule that allowed the Supreme Court to rule otherwise, no other sitting members of the executive, absent Councilor Fonante Kofa and the majority, this issue cannot be addressed any longer unless the rules and the ability for the court to decide it is done. But people reading, if you're not a lawyer, when you're reading the Supreme Court opinion, you will say this is what the court said. No, the court is only lifting those arguments, citing them, quoting them as the party quoted them. Doesn't mean like most people you ask a question, why is it called in unconstitutionality? Many Liberians are running with it and say the Supreme Court said in unconstitutionality. No, this is how the case is captured. This is how the party this is how Councilor Fonante Kofa.
And so what you were saying, which is the Supreme Court final opinion or judgment after analyzing the arguments from the parties, is wherefore, and in view of the foregoing, any sittings or actions by members of the legislature wrought in conformity with the intent of Article 33 and 49 of the Constitution are ultra vires. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this court is hereby ordered to inform the parties, and it is hereby so ordered. I would like for the two of you to explain that to our members. You go first, Councilor Chewe.
So the court, again, what you just read, the court is referring to the parties. If you just put it back, or you see the court is saying the reference. It says wherefore, in view of the foregoing, any sittings. It didn't say any sitting. Any sittings or actions by members of the House, by members of the legislature, not the House, members of the legislature, wrought in conformity, should be not in conformity, I think. Not in conformity with the intent of Article 33 and 49 of the Constitution are ultra vires. Now, many people have been saying that. In fact, I watched a video, I think it was live from Spoon Talk. The supporter of Councilor Fonante Kofa, there's J. Melvin Cole, and I think two other people that I saw. People lifted them on their shoulder. And they started to dance before even the lawyers came outside from the Supreme Court. So by saying it was ultra virus, they are saying that this is what the court said to the majority black. No, that's not what the court said to the majority black. The court is saying any one of them or the group as a whole, the legislature functioning outside Article 33 and 49, it would be considered ultra virus, not the action that they were performing. So again, Councilor, if you notice, I'm sure you're following, you will notice that Councilor Kofa and his group has so far filed a bill of information, told the Supreme Court to say, tell her who won, tell her who lost.
So, Anthony Freeman, the court is saying here that something is ultra virus. And I read that again. Wherefore, in view of the foregoing, any sittings or actions by members of the legislature not in conformity with the intent of Article 33 and 49 of the Constitution are ultra virus. In this case, the debate here is that people are saying, well, it was Franti who went and complained about the sitting of the majority as being unconstitutional. And now the court gives a final ruling and saying all sittings and actions, Franti is complaining about the sitting and the actions of the so-called majority. And now the court saying all sittings and all action not in conformity with Article 33 and 49. And 49, you know what 49 is saying? All right. They 49 is talking about what? They should have the 2/3 in order to remove the speaker. And that they didn't meet. They didn't get that required number. So people are saying, look, this ruling here, the court is talking about the majority Black and not of Frantisa, and Councilor Jewe is saying, no, not necessarily. What's your reading of that?
The first thing people need to know is that that is not how the Supreme Court normally issue a ruling. It's normally not that way. If the court is going to rule for you, the court is going to say, for example, Mr. John Brown, you are wrong, and I rule against you, I'll fine you this amount of money, or I order you to go to jail, stuff like that. The court is not going to give an open-ended ruling. So if the court want to rule for, yes, this is not a typical ruling of the Supreme Court. I'm just trying to look for another Supreme Court opinion to show you that this is not typical of how a Supreme Court normally issue their opinion to say any setting. Because by saying any setting, a court is trying to tell you that I am not telling you majority Black is wrong or majority Black is wrong and Fonati is wrong. Something like that. So any is applicable to both groups. But the reason why Fonati has a disadvantage is because the court has already acknowledged that when you have a quorum, you can meet and you can take actions. That is in because the court judgments, the court opinion started from page 31. When you have a quorum, you can meet, you can take action. That is in consonant with the Constitution. It's also in consonant with the House Rule number 7, 8, and 13. And
Anthony Freeman, just to interject, you also know that the Constitution says when they meet, the speaker presides. And in his absence,
no. There's not in this ruling.
I know.
Okay. You also need to know that the House Rule.
My question is based on the judgment where it says the court is saying the sittings and actions.
No, first thing you need to understand that the court is not going to give you a ruling for you to imply what they said. The court does not do that. If the rule is going to be very clear that the rule against you, for example, if somebody is supposed to maybe get a death penalty, the court is going to say, we convict you and we sentence you to death.
I get it, Anthony Freeman, but the court is saying the sittings and action are ultra virus. Who's sitting?
It's for two parties. It's for the two parties. It's for the both parties.
Did the court say that?
It's not for one person. It's for both parties.
How you know that?
Because the court, I told you already, when the court is ruling for somebody, they will be specific. They will call your name or they will say defendant, and they will tell you that you are wrong. They will tell you what steps you're supposed to take to correct it. If they're going to fine you, they will fine you. If they're supposed to jail you, they will jail you or stuff like that. So the court will be very, very clear. So when the court tell you any setting without telling you which party, the court is simply telling you, look, all of y'all, you're in the wrong, and you go back. The problem
was there any illegal section or sitting by any of the groups that you know? Constitutional.
No, I don't want to add to the court ruling. I'm telling you.
I'm not asking you to add to the court ruling. You are the attorney law.
You're trying to get me to say
my job here
what is illegal, what is ultra. No, the court. When I see there, the court is speaking to both parties.
And how do you know that? That's what I want to know. How do you
know? Because if the court wanted to speak for Fonati, Fonati is the petitioner, they would have said petitioner.
Correct.
If the court wanted to speak for the other group, they are the defendant or the respondent, the court will have said respondent.
Okay, so for the sake of this argument and analysis, let me agree with you. The court is saying to both parties. So explain to me what actions and settings of the Fonati SAR that are ultra-virus, and also tell me what setting and actions of the majority Black that are ultra-virus.
Okay, I think what the court said very clearly, I think they spoke about the settings without triggering the 49 removal. That's what they were talking about.
No, I
mean there's a distinction. No. You asked me to ask me to clear the air. I clear the air now. You got to give me a chance.
Okay, go ahead.
There are settings in which they didn't occur. They didn't get the 49 or whatever, and there are settings in which they claim they got the 49. Okay, so there are two different settings we're talking about there. So if you claim you got 49, then that setting cannot be ultra-virus because that setting will be in conformity with the Constitution. If you
are you disagreeing with the Supreme Court opinion that
you asked me now, I told you I didn't want to add the Supreme Court. You told me
disagree with the Supreme Court. Are you afraid to disagree?
I can disagree, but I'm only trying to clarify or your understanding of what it said. I'm telling you that's not how the court normally rule. When the court rule, they will say petitioner will rule against defendant, or we rule against petitioner and will assign costs. For example, they can assign costs to the person, the losing party, or if both parties, none of them are like winning, they can divide the costs. So none of that occurs. So nobody can claim that they have won their case. But the reason why it is disadvantageous for Fonati is that the other party, because they have a quorum, will continue to meet.
Thank you.
And Fonati, inability to constitute a quorum, will not meet. So he will continuously be at a distance. And I told you, Fonati knows that there is de jure and there is de facto.
Thank you, Anthony Freeman.
The de jure is what is written in the Constitution that they needed 49. Fine, then you remove him. But the de facto way of removing is that we will deny him of a quorum and he will have to go on his own. And Fonati know both are legal.
Thank you, Anthony Freeman. I got your point. Councillor Joel, Anthony Freeman is saying the court is speaking to both parties that their settings and actions are ultra-virus. Do you agree that the court is speaking to both parties?
Not in conformity with Article 33 and 49. They didn't say any action. If it were outside of 33 and outside of 49, then they are ultra-virus. But if the person took an action and claimed that
any sitting or action by members of the legislature not in conformity
because at some point the majority Black was saying that they attained the 49. So at that point the sitting is in conformity. So they are saying if you sat without the 49, it's not in conformity. But if you got a 49 and you took other action, and that's in conformity. So the court is telling you, your goal, this is what we say. Go follow this ruling. But nobody can come and claim that I won the case and I didn't win. The only thing I can say is that Fonati is at a disadvantage because the other people will be meeting because they have a quorum.
And you said that. Let me get Councillor Joel's opinion. Councillor Joel, who is the court talking to here? Both parties or one of the parties?
The court is speaking to the petitioner and the respondent. It's speaking to the majority Black and the minority Black. Fonati Kofa is the lead petitioner in the majority Black. The majority Black is the respondent. Let's look at Article 49. Two things in there. One, Article 49 talks about the 49. It also talks about who is the presiding officer. And then what the court did was to switch directly to go to Article 33. And one is like you warning, maybe the way they put it is like you warning your son in a house and say you have to get ready, eat, take bath, and start studying your lesson by 7 o'clock. Anytime you did not do any of those things, or your children, anytime you did not do any of those things, you will be considered of violating what the law requires. Now, in order to remove the speaker, there must be 49. But also with the presiding officer, also there's an issue of presiding officer in there. The question is, could Councilor Fulanti Kofa not being part of the majority Black in the deliberation on a day-to-day activity constitute the sitting of the majority Black as unconstitutional or ultra-virus? The answer is no. Because Councilor Fulanti Kofa, all he did from time to time, he was in the country, he was not outside the country. He refused to go into the joint chambers. So the clever thing that the majority Black did was to make sure that the deputy speaker, because the law says in the absence of the speaker, the deputy speaker can preside. So they managed to get Thomas P. Fowler, who is the deputy speaker to Councilor Fulanti Kofa, and said to themselves, let Councilor Fulanti Kofa and his 28 or 33 men continue in what they call the regular chambers. We will sit down here in the joint chambers. We'll summon him, we'll serve him a copy of a complaint, we'll go ahead and reconstruct the committees.
Councilor Joel, at what point can the deputy speaker preside?
In the absence of the speaker.
And was the speaker absent?
Yeah, where the majority, again, practically where the majority was sitting. Go to what the...
But you can go to school and not go to class, right?
The issue...
Isn't that true?
Yeah, so...
a lot of people go to school and not go to class.
Go ahead, Councilor Joel.
Oh, yeah. The Councilor Fulanti Kofa went to work every day and sat with his 23 men, or 28 or 33 men.
Are you saying that he was not in class even though he was on campus?
That's exactly it.
If you because again the issue is one quorum. What constitutes quorum?
So legislatively speaking, what is class? Using that scenario, what is class? Is class when you have a
quorum? When you have a quorum.
Is class the designated chamber to conduct the business of the legislature?
Don't be. Okay,
so, Anthony Freeman, you have enough time. Let Councilor Joel.
So there was no designated.
I'll get to you.
There was no designated specific spot that the majority could sit or the minority could sit. What I understand, what they all were doing was that in order to renovate the joint chambers, they decided to go into what they normally refer to as the conference sitting. There where they went to start to do business, but what they understand that they were going to renovate the joint hall where the Senate and the House of Representatives met. But what the mistake Councilor Fulanti Kofa and his group made was that they thought that by sitting in the conference room, where all of them were sitting before the majority left, they thought that since the majority were not there, going to work every day and sitting outside, or going to school and sitting outside in the classroom, LU is an interesting place. When your classes, when I had a law school, there was a plum tree almost facing towards the executive and the legislative branch there. We should sit down out there. If you went early, you sit down. If it was not raining, you can sit out there and wait for the time for your class to start. What Councilor Fulanti Kofa then did was they sat in the conference hall, and they did not care to go to where there was quorum. So about 18 or more times, there was adjournment. So
let's tie it to the Supreme Court decision. Was any of the sittings of the minority, this meaning the fanatic group, was any of their sittings or action ultra-virus in any way constitutionally or legally?
No.
Okay.
Equally so, the sitting of the majority, the code did not refer to it as ultra-virus.
How so?
The code was saying any sitting. In other words, is if you don't sit in conformity with Article 33 and 49, your sitting will be considered ultra-virus.
Yes.
But having said that, if the court was speaking in favor of Councillor Fonanti Kofa, we were said the sitting of the respondent in the joint conference hall or in the joint hall of the legislature is considered ultra-virus. The court will speak very definitively, unequivocally, and very clear.
Okay.
And so then that reference the court would name the party, that party that is in the wrong specifically, and say your action is ultra-virus. Therefore, you are to return.
So, counsel, I mean, I like what the both of you are saying the same thing, and I'm getting your logic here. So now, this is my next question, because, and let's put that up again. Wherefore, and in view of the foregoing, any sittings and actions by members of the House of Legislature not in conformity with the intent of Article 33 and 49 of the Constitution are ultra-virus. My question for this, you understand, what is not in conformity with the Constitution here, the actions and sitting of these two groups, for which the court have to mention that? What is that?
So let me answer by saying, if the majority have sat in it, are sitting in that, they are not sitting in the joint chambers, right? If they were sitting in the joint chamber without a hearing officer, not hearing, but presiding officer, that is without a speaker. If they were just, because you notice when they started sitting in the joint chambers, Representative Guy, and somebody else were sitting as, I think Representative Guy was he was sitting as the presiding officer until they wrote Thomas Fowler. And if they have continued to have sat as the majority group, and no speaker or deputy speaker, mind you, in the absence of the speaker, the deputy speaker can sit as the presiding officer. So I think about a week or two,
and whether or not the speaker is in agreement with that, the deputy speaker can just for the deputy speaker to preside in the presence of the speaker, or when the speaker is available, the speaker has to release that authority to the deputy speaker to do so.
When the speaker is available, and maybe let's say they brought a letter from the mansion while a session was going on, and the speaker had to step out before he leaves to go to his chambers, to his office, to answer to what the emergency is from the executive. He would designate the deputy to sit.
That is what I'm looking for. Was he designated to go and preside on the side of the majority?
That is on a normal condition where the House is sitting as a unit. There's no conflict. There's no division. Then he could do that. But where the majority, they were first going back to the same conference hall when J. Melvin Cole and others locked the doors. And then
so in essence, you are saying at some point the sitting of the majority Black was ultra-virus because they didn't have the speaker or deputy speaker?
So yes. So when they started, and they were having what you call him, Representative Guy to be the presiding
officer.
They call him presiding pro tem. That's how they call him. But they thought that was a little bit too legally risky or politically risky. So they decided to get Fowler.
Thomas Fowler.
Thomas Fowler. So Thomas P. Fowler, Representative Thomas P. Fowler, Deputy Speaker of the House of Representatives, left the side of Councillor Fonanti Kofa in the conference room where they were sitting and joined the majority. Mind you, the majority have been meeting, having quorum. And once he joined them, and Councillor Fonati Kofa decided to remain on the other side, Councillor Fonati Kofa is considered absent. Therefore, the deputy speaker could sit and conduct the affairs of the legislature, having had quorum, having had the sergeant in arms to cry the opening of the day session, having had prayer. So Councillor Fonati Kofa was very much at a disadvantage, not knowing, not understanding that his action to say we will not go there, we're still on this side, created a problem for him. So the court was saying, look, if any one of you sat outside of what Article 49 and 33 holds, that is, if the quote unquote majority has sat without a quorum, the action will be ultra-virus.
My final question to you to bring Anthony Freeman in. Constitutionally speaking, who is the administrative leader of the House of Representatives?
So Article 49 says that the Speaker of the House is a presiding officer. But in the absence of the Speaker, the Deputy Speaker may preside. So it's not set in black and white that when once the Speaker is absent, the authority to conduct the affairs of the House falls on the Deputy Speaker. And all the majority said was that 1, we have a quorum. 2, we have the Deputy Speaker. 3, we have the sergeant in arms. 4, we have the chaplain. And we've been conducting business in conformity with Article 49 because the Speaker deliberately chose to absent himself from the majority. And that made him, like you said, your child went to school, but just sat down in Tottenham High Yard, talking and playing with his friends, where the class is being conducted. Your child cannot come and say I was part of the physics class.
So you're saying that, well, the classroom was changed from room 49, I'm using that as an example, to room 48. And now my son is saying, no, that is not our classroom. So my question there is, who has the authority to change the classroom? Is it not the administration of the school? In this case, the administration being Franti?
No. Once there were no quorum, Councillor Fonati Kofa decided to adjourn from time to time. Mind you, in Article 43,
does that make him to lose the administrative authority?
He's absent from where the majority was sitting, where there was a quorum, because there's no way it says in the Constitution that the room that they were sitting in, the conference room, is considered as the place that the Constitution is supposed to sit.
All right. Or
the joint chambers where the majority was sitting. So having done that, the thing is there a quorum? Where is that quorum? Is it with the majority? Is there an absence of the Speaker where there is quorum, where the majority consider themselves plenary? If the answer is yes, then is there a presiding officer? In this case, the Deputy Speaker. If the answer is yes, then their action cannot be ultra-virus.
All right. So my final question to you, has the Speaker been removed constitutionally and legally with the required due process?
So the answer to that question is yes. Let's go back to the conflict.
I gave 3 benchmarks: constitutionally, legally, and due process. Do you say yes to all 3?
The answer is yes to all of them.
So I'm not clear on the due process. Tell me the due process that they were able to fulfill.
So first, in order to get 49, in order to remove the Speaker, the majority needed 49. Mind you, when this complaint or when this issue started, there were, I think, 51 or 52 people who went and signed the resolution. 5 of those people, after a while, they decided to say, oh, no, we no longer will be with the majority black. We're going back to Councillor Fonati Kofa. And what they did in order to say they were declining from being part of the majority black was they went to some justice of the peace in Liberia and they signed statements and notarized those statements and brought it and said, show it to the press and say, you see, we are no longer part of the majority black. But in order for it, and so their number was not legally removed from the majority black.
Okay.
The 5 that left, who said they left and had affidavit, they went before the justice of the peace and swore that they were no longer part. They were not properly removed.
So in essence, the resolution that they had signed, majority signed a resolution, I think 50 or 51, that about. Are you saying that resolution that got the signatures of about 50 or plus was enough and was enough for the removal of the speaker? No other due process needed to go on?
So let me tell you why it remained binding on them. When they got their statement notarized and came back, had the justice of the peace signed and brought it back, under their procedure according to them, the 5 members were to come back to plenary and file copies of those affidavits that they have signed to say they no longer belong to the group that were the majority black that was about to remove or wanted to remove Councilor Fonante Kofa. It was not enough to notarize a statement and come back to the house and sit down and call the press and say, I think one of the representatives or Representative Cooper, they called press conference and said, we're no longer part of that group. That was not a way to leave. That was not a way to say that they were no more part of the group. They should have come back to plenary and file those documents with the clerk.
I get that part, but my question now is that now that they were not able to remove their names or signature from the resolution legally, and that removal did not hold, are you saying that the 50 or 51 person that signed the resolution, that resolution is enough for the removal of the speaker and no other due process required?
So that I guess your question is whether they should have called Councilor Fonante Kofa, whether they should have conducted a hearing. No, the law just say by a 2/3 majority resolution for cause. So the majority continue to count the 5 people who left. I say, hey, you say you left, but you are still here. We're going to count you by what you have done. And we will use that to go ahead and declare it and declare the, I think, vote and declare the seat vacant, the speaker's seat vacant. And we are going to go ahead and elect Representative Richard Nangbe Kun as the speaker. Had the five representatives that left, had they consulted a lawyer as to what they were doing, and had they been told clearly that they're leaving the section were meant injury to themselves, I believe that they would have understood better and acted better.
Thank you.
So they had quorum, and so for the 9 was obtained, and so Councilor Fonante Kofa was removed.
Thank you. Anthony Freeman, has Fonante been removed legally, constitutionally, with due process?
The Fonante was invited to an investigation. He chose not to go.
Okay.
So if I invite you to an administrative hearing or any kind of hearing and you choose not to go, what am I supposed to do? You tell me.
You rule in, how do you call it, abstention?
You make a decision. The court is not going to, or whatever forum it is not going to wait for you endlessly. There is no forum. And every time your lawyer, even if the person, you believe that the person does not have the full legal authority, you are supposed to go there and tell them that they do not have the full legal authority. That's what you're supposed to do. Because what we call it, you are creating a record for appeal. But if you choose not to, they can make a decision contrary to your interests. Fonante knows. Working is the only thing I don't know. But Fonante knows all of this.
In that case, you're citing, will it be at the discretion of the court that, oh, well, this person was invited to appear because we could possibly make a judgment yet. They didn't come. So we wrote in right away, or with the court decide to say, well, let's invite the person for the second time.
The first thing is that it's not a regular court, it's an administrative process or whatever. So it will not follow the path that you see in a regular courtroom. And that is not a meaning of due process. That the same process, no, give me a chance, give me a break. The process that plays out in a court is not necessarily the process that plays out in an administrative hearing or in a parliamentary hearing. They are different. The basic thing is that you must be given an opportunity to present your case and to object to what they're doing if they choose to. Because by objecting, you create a record for you to appeal. So if they invite you, I'm emphasizing, even if you believe that the person lacked the full legal authority, you still supposed to appear and challenge them. But your failure to appear is waiver, we call it waiver and lashes. And Fonati knows it's just the common people that is being pushed around, but Fonati knows that he's suffering waiver and lashes. Firstly, he was supposed to go in the forum and demand to preside. He refused. He suffered lashes. Then when they invited him, he was supposed to go there and challenge the authority in their own forum. He refused. So Fonati knows. No, let me tell you what is going on. Fonati is aware that he has lost. But the ignorance of the general population, because the guy have long played on the ignorance of the population, so they continue to play on the ignorance of the population. And, you know, to stir up trouble in the hope that maybe some kind of ad hoc arrangement for him to stay hang on to his $2 million budget. Okay? But nothing, the first thing you need to know, if there were actually a due process issue, the court would have ruled for Fonati. I want you to get that part clear. There is no way a case will go to court and the person raised due process. If really a due process issue was there, there is no way the court will send that case back without ruling on the due process issue. But the court must have weighed in and see that there is no serious due process issue there and decided not to even mention it as part of the. Mind you, if you look at the last paragraph on page 33 and the second paragraph on, the first paragraph on page 32 and 33, you will see that the court is effectively saying that we recognize those sessions that there were quorum, because we know that at some point in time, we will not always get a full house. So anything less than a full house, but it meets the quorum, they can transact business. The court said it in the last paragraph on page 32 and the first paragraph on page 33. The court said it. So don't get carried away because you go to court, you don't show up, then the judge, even that, there are many rulings that the court said no judge is obligated to write you the second time. No judge is obligated to write you the second time. If they serve you, you receive that summons, the writ, whatever, and you choose not to, it is within the discretion of the judge to decide, I will send you another notice. But the judge can decide, I'm not sending you another notice. You were duly cited and you fail to show up, will rule against you by default. There is no law. I challenge anybody to cite any law that when you fail to show up for your court hearing, that you have been duly cited, that the court is under obligation to write you a second, a third, and fourth. No court is under such an obligation.
If you are just joining us, or if you have been here, this is Focus on Liberia Justice Forum, and I have been in conversation with Anthony Wonder Coyne Freeman and Focus on Liberia Legal Analyst, Counsel of Federal JWA, and we have been discussing the topic, analysis of the Supreme Court opinion in the JFK, that's a Jonathan Fonati Kofa, and the majority Bloc case, and the Supreme Court came up with a judgment, and they are providing some understanding, and I'm sure you've been following. We have opened the phone lines for you to participate by calling. It's posted here in Facebook. Here is the number, 605-313-6004. Enter the code 403 hash for you to participate. Look in Facebook, look on YouTube, wherever you're watching. The number is in the live feeds, both Facebook and YouTube. I want you to call to ask your question. If you have an opinion, we also want to hear from you. This has been a fascinating discussion. Gentlemen, while we wait for call, my next question, starting with you, Councillor Jewel, will be this whole issue about Funanti saying he's not resigning and that due process was not followed and that the majority bloc did not get the 49 or the 2/3 as required by the Constitution. Does he have an acumen constitutionally speaking?
Let me give you the legal briefing.
Mm-hmm.
When this case or this conflict started, the first thing that Councillor Funanti Kofa and his legal team did was they fled to the Supreme Court
mm-hmm.
and filed a petition for a writ of prohibition to stop the majority bloc from operating from the joint chambers and to undo all of those things that Councillor Funanti Kofa and his minority supporters decided were unconstitutional. The justice in chambers declined to issue the writ, meaning he refused to agree with Councillor Funanti Kofa. And so the prohibition was not issued. And the party returned to what they call status quo ante, returned to where they were. Funanti Kofa were back to the room that they were meeting. And the majority remained from where they were meeting, went back to where they were meeting. After that, Councillor Funanti Kofa and his legal team said, oh, okay, the prohibition is denied. We are going to go to the Supreme Court to interpret these articles of the Constitution there where they had it in read. So they went to the Supreme Court on the in read. While that was pending, Councillor Funanti Kofa and his legal team was not certified. They said we're going to file a petition for mandamus, a petition that will compel the majority in their prayers, wanting the Supreme Court to compel the majority to return to the minority. So there were three legal actions taken by Councillor Funanti Kofa. Any lawyer who knows the practice of law in Liberia and the tradition very clearly will not jump from one petition to another petition, hoping that you can guess. When the first petition doesn't work, then you look for in re. When in re is pending, then you also file a mandamus using the same press. If you read the in re and the mandamus, you'll see they're the same press. So to begin with, practically, when the majority leaves from your authority, as the Speaker of the House of Representatives, your duties, your cry of unconstitutionality.
Legitimacy. Has he lost legitimacy? Is that what you're saying?
Yeah. Yeah, he lost that. The spirit and the intent of being a speaker is you are speaker of the house. You are not speaker of some member of the house. When the majority leave from your authority and say, we don't trust you any longer, we will not sit where you are sitting because you are corrupt, because of this, because of that, they raise the costs and are representing government agencies and whatnot, and will move away. And that moving away, they have quorum with the deputy speaker sitting. Councillor Funanti Kofa can decide to say he will not resign. But guess what? The executive rely upon that decision and the interpretation and the opinion written by the justice minister will remove the security from him.
And so let's talk about that. the opinion, I don't know whether it's an opinion, I don't know whether it's an interpretation, but I will say the statement by the Attorney General, the legal advisor to the president. What is your reading of that? I know it is a right to read things the way he sees them, but did he read it right? Did he get it right? Do you agree with him?
So the Minister of Justice is the chief legal advisor to the president.
Mm-hmm.
He is the only minister within the government of Liberia that can advise the president on how the president is intending to proceed. The new executive law gives him that power. Now, his advice is like when a lawyer in his law office say, you are my client, and before we go to court, I will decide to write you a memorandum, legal memorandum, to lay down your position and what I think the other side that is suing you, what the legal position is, and in general, what the court will decide if we ever went to court. Or better still, this matter can be decided outside of court because of all of these legal loopholes that could impact you as my client. All the justice minister did, and I agree with his opinion. All of what he did was to tell the executive, the president, the head of the executive branch of the government, the president, that Mr. President, the majority had quorum. The majority had the deputy speaker. Let's do business with the majority. So he was not. People were saying that he interpreting the decision of the Supreme Court. No, he was not interpreting the decision of the Supreme Court. He was stating to the president legally how he understood the decision to be. He was not adding or not subtracting. He said, this is my understanding, my opinion is that the government of Liberia must deal with the majority. The majority has quorum. The majority has the deputy speaker. The minority have been adjoining from day to day to day to day. We can't go on that side. We can't get our budget on that side.
Mm-hmm. All right. Thank you.
Let me intervene in that particular point.
Please, I want you to weigh in, and we'll go to the callers.
Okay. Mm-hmm. Firstly, I think it's of no legal effect.
Correct.
It was intended for the president maybe to view it, but in terms of the country, there is no legal effect, because when they say the Supreme Court is final, it means final. So when the Supreme Court make their opinion, not much you can do about it. So I don't see what the point, but I want to take you to the ruling. Mm-hmm. If you go to page 27 of the ruling, mm-hmm. I want you to go there.
All right, let me go there quickly.
Page 27.
27 is the page. All right.
Yeah, page 27.
Mm-hmm.
Before
where's
the
wherefore?
Yeah.
Where you want me to read from?
Oh, I just want you to see that position that there's the Ministry of Justice made 3 points, and that point was incorporated in the Supreme Court ruling. Mm-hmm. Point number 1 in paragraph number 1 mm-hmm. is that the executive does not want to weigh into this matter. Mm-hmm. Point number 2, they do not want to advise the Supreme Court before they exceed their jurisdiction. And point number 3, they wanted to be dropped from the case totally because as far as they're concerned, they got no fish to fry. Mm-hmm. That was the precept that they sent to the court when the court was making the decision. So the petitioner, which is Fonati Kofa, the court took his petition, the respondent, the majority black, they took their own opinion, and they so he already wrote an opinion. Okay, so now he come by, he writing another opinion. That opinion that he writing after the fact, after the Supreme Court ruling, it has no legal effect because he wrote an opinion already, and the court took his opinion into consideration prior to making the decision.
And so, do you agree with how Councilor Jewett explained the Justice Minister advised to the
I
president.
disagree. You can see that my position is different from his. It's very clear.
So he had no reason of saying anything. Is that what you're saying? Or why he said? Are you saying he had no reason of saying anything, or why he says it's wrong?
He got a right to talk to the president and write anything he wants, but for the public, it has no legal effect on the public. So he get a right to write the president and offer any number of legal advice, but in terms of the public, it has no legal effect on the public.
All right. Thank you. With that said, we will go to the callers, and callers, I'm coming to you right now. Get ready, and those who have not called, you can also call. We want to hear from you. Let me see who we have here ready to go. We have Vincent Kier. Mr. Kier, you are live, and you have a minute.
Yeah, thank you for the show. No, listen, this is not some part for small or Bagashi or already Bagashi. So nothing different. Listen to those people, those my two brother on our show. Listen to their opinion. That tells you that the country will find out saying, with every education people have, but when it comes to reality, to be a fair in analysis, as long as you support this thing, you don't care about the state or the society. Listen to what you just see. This is so painful to the extent that we have a country that will call Liberia. And this is not easy. We're going for years in a type of situation. The same thing I made Liberia will be that this thing happens. They still encourage people interpret the constitution in a way they want to be until they find in a situation. This is still people doing.
Mr. Kier, are you disagreeing with somebody or something? And what is that?
Are you talking to me?
Yeah, I'm asking you, are you disagreeing with someone or anything, and what specifically is your point?
I disagree with it. I disagree with it. I listen to saying the speaker should go to the majority black and start. Can you imagine? Are you sure?
So do you see? So what you think is supposed to happen? What you think is supposed to happen? What you think is wrong here?
Mm-hmm. The wrong is they violate the constitution to leave a place. Anything they want to say to the speaker, they should be there and make the speaker resign and control the case. Instead of making go to different place, they saying the speaker will go there for them and to resign all them. So
Mr. Kier, you saying that you disagree with the Supreme Court ruling? Oh, okay. So what you think is the Supreme Court ruling that they're not saying?
All those things are happening now about us. When the majority of I don't know what the majority are doing. It's illegal.
Okay.
And you just ask the same question.
Yeah.
What is illegal? Is there nothing?
Thank you.
What do you have to do illegal? Is there nothing?
Thank you.
We want to tell me the Supreme Court ruling has nothing. They don't know about legal law. The way what they have to say is other power. Because somebody do something not correct. I would say other power.
Thank you, Mr. Kier.
Somebody do something why would do it? But they say no issue.
Thank you, Mr. Kier.
The majority issue. So we don't have issue now.
Thank you. The caller disagree with both of you. He's saying if the Supreme Court says the action not in conformity with Article 43 and 49, ultra virus, then why are you saying anyway? That's his position. Let me go to the next caller here. That would be Togba Emmanuel. Mr. Togba, you are live.
Yes, thank you for taking my call. First of all, the two lawyers discussing this issue, they are very biased. I think they take the position that they have always taken before, and then you bring down the show that is called Justice Forum. I would have expected to see another group of lawyers, like 2, maybe, or 4 lawyers debating the issue, because their view, I already know the view of Captain Chile. From his discussions on the basis of focus on Liberia, I knew the view of even Korean. See, the Supreme Court said the actions, any statements and everything is ultra virus. You have other lawyers in Liberia, for example, Councillor Kawan Bongo, you have Councillor Maria Kekula, you have so many other lawyers that say the opposite. Okay, so how can somebody be right or they won the case and he has lawyers divided? But anyways, they are lawyers, that's what they do, right? Because, for example, the guy who just shot somebody in broad daylight Miami, in Manhattan, he got a lawyer, and the lawyer has evidence, and the people get down and their evidence. So, the lawyer will do what he can do, and the side they on, they will defend their side, but he's wrong, okay? I'm not blaming the lawyers, I'm blaming the Supreme Court. Johnny Louis Supreme Court would not have given that kind of ruling, okay? That kind of ruling, it will be straight to the point. But because they give some academic ruling, so we have opinions on what it says. That's my contribution. Thank you.
Thank you. Let's go to the next caller here. Caller phone number ending in 8789. I think the name here is Jomala. I hope I got it right. You are live.
Yeah, Jomala McEwen. Thanks, man. Thanks to the legal expert, in the studio, I just wanted to retrospect it, What I want to retrospect is that since the post-war political indoctrination by Ellen Johnson Sirleaf, the executive mansion has developed political interest in who becomes Speaker of the National Legislature. I think that is why troubling. You know what I mean? Because look, man, try to retrospect. Every time there will be some kind of, manipulation or financial, kickbacks or bribes to remove a speaker. So what is the interest of the executive? These are three separate branches of government, right? Why is it that the executive always wants, to orchestrate, a political removal of the speaker? What is going on? I think that's the issue. But to question Councillor Jawe and question the other lawyer, I don't have the authority. That's my contribution, Thank you very much.
Thank you there. Those are the callers we have until another caller can come. Councillor Joel.
I want to make a quick point.
All right, you go first.
Hang over where they start to have a discussion. Mm-hmm. What if there was an earthquake and the Capitol building went underground? Will the legislature not meet? So it's not very important, where they meet and all of that. The fact is they got a quorum, they went through the procedure and they met, that's it. So don't get carried away because that place could be, maybe a terrorist could blast the Capitol building, then what? Then they will not meet? They have to meet. So it's not very important. The law says they should meet in the capital city. If they meet in the capital city, that's it. There's nothing else to it. And people, the funny thing about Liberia, everybody that expert. So lawyers on the show told you before the Supreme Court ruled that this is a political question. The Supreme Court ruled this is a political question. After the Supreme Court ruling, we come back on the show and tell you this is a political question. But Liberian people still, who are non-lawyers, arguing that the Supreme Court said what they wish the Supreme Court to say to them. What's that? It's being unscientific. We are telling you from experience, from training, what it is. And you are making an issue that, no, it shouldn't be where it is. What I feel in my heart, that what it should be. A law is not about your heart. It is about a scientific approach to decision making. It's not about how you feel in your heart.
Councillor Joel, I think most of the callers have reservation with your expose here. In their minds, well, the man is the Speaker of the Constitution for the 9 saying, well, you should have 2/3 for the 9. And we have heard so much about this due process. Franti is propagating that. The callers are saying that is not the case. The caller feel that this is a simple matter. Franti himself said, look, if you get it 49 out of here, they don't have the 49. You are saying, well, they have a resolution, but the audience having a disagreement. Yeah, they can't believe that this simple matter, in their opinion, is something that Supreme Court is not making a decision. It's creating more confusion. Where you stand?
So the ordinary Liberian would say that this is a simple matter. Like you taking a taxi driver into JFK and he said the taxi driver should perform C session. It's impossible because the taxi driver will not be. It's not a doctor, so he doesn't know what is happening. This is not one of those cases where the Supreme Court will just rule and say the majority of blacks should return to status quo, antique return to the authority of Council Kofa. Even all the callers have not taken into consideration the explanation we gave when it comes to what is called the political question doctrine. That's a complexity for ordinary person who has not gone to law school to understand what is meant by political question doctrine. Even the separation of power issue that the Supreme Court raised, that is not also addressed. That is not understood clearly by the public. The propaganda have been, again, if you saw when the Supreme Court, before it could even conclude its ruling, Mr. J. Melvin Cole, one of the supporters of Council Fonanti Kofa, was lifted up outside Temple of Justice in the yard, was lifted up and carried on people's shoulders that they have won. They themselves did not understand the ruling of the Supreme Court. And so they went ahead and decided to, jubilate, dance, buy beer, buy wine, as it is, and begin to dance around. But this is a highly complex decision of the Supreme Court. Ordinarily, people understand that, why the people did not get 49, then they say they remove Fonanti Kofa. And Fonanti Kofa and his lawyers are also going around and giving this simplicity when it's not as simple as they think about it. I don't agree that, I understand Liberian would not agree with what is being explained, but again, you will not explain something complex. And then ordinarily people just buy into it. Because they already have the mind made up. In fact, I went on the show with closing argument. And almost every member on the closing argument have already had a made up mind that Councillor Fonanti Kofa won, that the decision of the court was in favor of Councillor Fonanti Kofa. Why was Councillor Jewel explaining the way you were explaining? Again, I did not fault them because I know they are all non-lawyers. And I also know that they were giving their own interpretation the way they felt. But as it is, this matter is done. Going to the Supreme Court for the second time, on the third time for bill of information, the Chief Justice has not signed. That bill of information is not going to be heard until the Chief Justice can sign on to it. The court has the right to refuse the bill of information outright without an opinion. With one sentence, we reject this information. That's it.
So we have to go now. Time is fast spent. The final thing is that Fonanti reported that his security details have been taken away by the executive. And so I asked the question, if that is true, is the executive right to remove Fonanti's security details? Does the executive now sees that Fonanti is not the speaker? Are they recognizing Rachel Kuhn and prepared to do business with him? And is that a solution to this matter? Councillor Joel?
Again, as I said, Councillor Fonanti Kofa is done. With the ruling of the Supreme Court and the opinion of the Attorney General, the director of the Liberian National Police, and the what we used to call SSS, it's now called EPS. They have visited Speaker Kofa, former Speaker Kofa, and told him that the EPS people will be taken from you. Their police protection will also be taken away from you. Government vehicles and government items in your possession will be taken away from you. Councillor Fonanti Kofa, in spirit and in practicality, he's gone. Rachel Kuhn, the executive, is beginning to deal with him already because, in fact, the Senate has started to deal with the majority black. Nothing is left for Councillor Fonanti Kofa.
Thank you. Anthony Freeman, Same question.
There's one point in this statement that I think we didn't consider, and I want people to understand.
Okay.
So, why didn't we're not getting here? Why didn't the Supreme Court say Fonati won? Like, we rule for petitioner, and we ask or respondent to submit to the authority of petitioner. Why didn't the Supreme Court say that? Liberian people should not forget the Supreme Court does not live in a vacuum. That very budget that they're supposed to discuss, the Supreme Court got interest in that budget. So the Supreme Court using ordinary man standard is not going to rule for Fonati when they know that Fonati will not discuss the budget and will not pass the budget.
Attorney Freeman, how are you not suggesting that the Supreme Court?
No, I mean there are unspoken issues. There are unspoken issues, ruling that people don't talk about because it was not written.
So you want to go into that territory that the Supreme Court may be?
I'm not telling you this is a legal matter. I'm telling you there are unspoken issues.
Because it does not want the country to get crippled economically.
Look, there are philosophy when you are ruling, right? In America, they say conservative and liberal, right?
Yeah, liberal.
The conservative will go and look for parts of the law that support their conservative causes and write a ruling to suit their version of events. So they can tell you that, when the fetus is 1 day old, that's a human being. Okay, the liberal will go and write their ruling to suit them. So there's always a philosophical, and there are other approaches that impugn on a Supreme Court ruling. So I'm telling you, there is what we call law and economics. Sometimes the court rule based on economic consideration. That is something that may not be familiar in a lot of Liberian lawyers because they only know how to go to court and argue, but they don't know the philosophical aspect.
National security considerations.
There may be that philosophical perspective. I come from the background of the law and economic perspective.
I know.
So people know me as a financial oriented lawyer. So I'm telling you, the Supreme Court is not going to rule for an individual who will not pass the budget. Think about it. They will not write it in
the Supreme Court needs the budget to function as a body.
So to rule for an individual who will not pass the budget is to rule against their own self-interest. So Liberian people start making noise. Once people who understand the nitty-gritty of these things telling you, try to learn from it and start arguing endlessly. No, every lawyer has a philosophical approach. For example, J. Webb, he has an extensive human rights background. When he approaches a case, he's going to be weighing it from a human rights perspective. It's not written in the law, but that's how he's going to weigh it. I come from an economic and law background, right? A financial background. When I'm weighing things, I might have that kind of.
I said financial crime emphasis.
Fine. So I might have that kind of approach. So the Supreme Court, I've seen it from my background from law and economics, that the Supreme Court will not rule for a person who cannot pass the budget. Period. So they may not like what the majority is doing. They say, no, we wash our hands. Y'all go solve it. In short, you pass our budget so we can continue to operate.
One man business. The contract.
All right. One monkey can start the show.
Folks, this has been a fascinating discussion. This is how we'll come to the end. We will solicit closing arguments because we are in court now from our lawyers. Gentlemen, I'll leave 30 seconds each because time is fast spent. You go first, Anthony Freeman.
Okay, so I want the Liberian people to understand that there is a de jure aspect of law and there is a de facto aspect of law. Mm-hmm. And both are legal. Something may be written in the law. You see it there, it says that's the de jure aspect of it. You need 49 to remove the speaker. The de facto is that the speaker needs a minority, a majority, simple majority to constitute a quorum. But if he can't constitute a quorum, in effect, he's not a speaker. That's the de facto. So both are legal. There is nothing illegal about it. That if you can't reach maybe the 49, But if you can find another way to get to remove the speaker without the 49, all two are legal. Okay, so people should not, get so hung about. The second thing is that when the Supreme Court wants to rule for you, they will call your name, they will tell you won, they will tell you they will award you compensatory damages, punitive damages, or if you lost, they will tell you, okay, you got to go to jail. They will be very direct. If the Supreme Court decide to issue what we call a bow-legged ruling, that means, my man, I'm washing my hands from this thing. I will not tell you I'm washing my hands, but I'm washing my hands.
So in essence, your advice, your legal advice to Fonanti, your legal advice to the executive,
Fonanti should put the country before himself. Fonanti should put the country before himself. That's my advice to him. And I also would like Liberian people to ask about the $7 million that the Fonanti spent over his budget. Let's investigate that and start making a lot of noise about how he will remove. Because that $7 million is more important to Liberia than Fonanti.
And any legal advice to the president or the executive, non-president in particular?
Well, I just think Mr. Bwaka is the most incompetent person. I didn't know that somebody could be worse than George Weah, but now I realize that Bwaka is even far more incompetent than Weah. That's what I have to say about him. Unfortunately, the country has been mortgaged for the next 6 years. So those who promoted the Bwaka presidency, I hope you see the damage that you have caused to this country. That's what I have to say to Bwaka.
Thank you. Well, Councillor Jewett, you get the final opinion in this court.
I appreciate the view of the Liberian people from out there. Also sympathize with them that this is not a very simple matter. That it is always good to go when you get sick, you go to the hospital and perhaps tell the doctor what is happening to you and leave it with the doctor to handle all of the technicalities. The argument that the majority did not get a full 49 people to remove Councillor Fonanti Kofa, that's an impractical argument. Once Councillor Fonanti Kofa lost the respect and legitimacy from his colleagues, mind you, he was representative first before he was elected as a speaker. Once they moved away from him and he no longer could hold any session, but to adjourn for more than 18 different times, that puts him in a great danger of not functioning anymore as speaker. And the Supreme Court, as we know it, will come down very clearly and definitively. And it will say, wherefore, and in view of the foregoing, the petition of the petitioner is hereby granted. The court will say that. And that the respondents sitting in the joint chamber is unconstitutional and ultra-virus. That's as clear as how the court will put it. But the court said, this is a political matter. This matter can be easily decided by those who are in the political branch of the government, the House of Representatives. We are not going to decide. We'll send it back to them. Let them decide it. What did the court say? Who, on the political level, Councillor Fonanti Kofa, you have lost legitimacy. That's what the court was saying in essence. And so returning to the majority is not helpful for Councillor Fonanti Kofa. And lastly, I would just add that Councillor Fonanti Kofa has again misled the people who support him by running to the Supreme Court and say, we here on a bill of information, asking the Supreme Court to interpret its decision. The court could accept the bill of information, or the court could refuse to act on it at all and say, our decision stands. With one sentence, this bill of information is rejected. My information at this point is that what Councillor Fonanti Kofa and his lawyers are doing, they're trying to see whether the Chief Justice can sign, because she must sign in order for the matter to be brought before the full bench. I think some of the justices have signed. but the court can reject it. And Councilor Fona Kofa, I said yesterday when I think on our forum that the lawyers are advising Councilor Fona Kofa would do well to allow him to live in peace and with respect, other than the security being removed from him, other than the vehicle being taken away from him, other than the chair that he used to sit in is not being taken over by Honorable Richard Nangwe-Kun. He will have to sit if he wants to remain in there, he will have to sit in a general pew where everybody else sit. Like when you go to church, you can't.
Is there a specific office for the speaker? Or
yeah. I understand there's a specific office. The executive has told him that they will come for the key. You should have the keys available. If you have anything personal in there, you should take them from there.
Or else he will be evicted.
Yeah, they will evict him. You got the top security people went to him already, the police director, and the director for EPS already informed him that we're coming for our police, we're coming for our EPS, we're coming for the vehicle. So if he doesn't do that, you will see that he will be traveling in one of the vehicles, they will stop the vehicle and pull him down. Particularly if that vehicle was bought by the state. The executive will do that. The vehicle was bought by the state for the speaker. And he no longer speaker, you cannot ride that vehicle anymore. You don't want those things to happen. He turned them over and then perhaps remain there or resign from the House of Representatives and go to be a lawyer in his law office. And I said another thing, that his office will become like Sherman and Sherman. You know, when you're in government in Liberia, you hold in B position, all the clients can come to you. When you move from that position, they will run away from you. Firestone will go away, Lamco will go away, Godry will go away. All of these companies that are fooling around him will all run away, and International Law Group will be no more.
All right, that would do it for today's edition of Focus on Liberia Justice Forum. We want to say many thanks to those who follow and those who will follow later. Thanks so much, Councilor Jewel and Anthony Freeman. We will now close with our song that says, "We are indeed all Liberians." Until we meet again, enjoy that song and bye-bye.
We are Liberians. Liberia is our